The next case on the docket, NUZZI versus State.
Good morning.
Morning.
My name is O.H. Eaton, Jr., and I represent John NUZZI. Mr. NUZZI filed a motion for post...
Let me reset you, get you going. How much time would you like for rebuttal?
5.
All right, you got it.
Mr. NUZZI filed a motion for post-conviction relief alleging 3 grounds. The trial judge found that ground 3 was sufficient to justify holding an evidentiary hearing, so he scheduled an evidentiary hearing. Mr. NUZZI filed a pro se motion for appointment of counsel, and the trial judge denied it. The issue in the post-conviction relief motion was ineffective assistance of counsel.
You think you need an expert witness to establish ineffective assistance of counsel?
I have never seen a successful motion for post-conviction relief involving ineffective assistance of counsel that didn't have at least one expert witness.
My question is, as a matter of law, do you think that you have to have an expert witness to establish ineffective assistance?
I think you do. I know if I were trying the case, I would want to have an expert witness to tell me something, to have it in the record.
What case would you cite for that proposition, then?
I wouldn't cite one because I don't have one, but that would be my feeling. But in any event, assuming that you don't have to have an expert witness, it's still an evidentiary hearing. Now, the trial judge in this case
What's the purpose of the evidence in this case? Is to determine what fact? What's the ineffective based on?
It was based on the fact that, and now, the motion alleges that it was ineffective assistance for the lawyer, the defense lawyer, to call his client to testify.
It was ineffective. The motion says it was ineffective for advising the client that he should take the stand.
Right.
The brief says it was ineffective for calling him to testify, basically making it sound like he was compelled to testify, but he was given the choice. Just the lawyer's advice was, maybe you should take the stand to explain your defense. But he was given the choice, right? He wasn't forced to testify.
Well, that's true, but remember now, the trial judge made the finding that the motion was sufficient to justify an evidentiary hearing.
To determine what advice the lawyer gave to the client.
Well, no, you're not listening.
I think I am listening, Mr. Eaton. I'm not sure you're listening.
All right.
The factual dispute was, what advice did the lawyer give to the client? And then if it was what the client said, then was that ineffective? There'll be a second part of the hearing, then you get into the argument. But isn't it a factual dispute of what the actual advice was that the lawyer gave to the client?
Assume that's true. The problem is that the NUZZI requested to have a lawyer appointed to represent him. If a lawyer had been appointed to represent him, the issue may have been couched in totally different terms, because a lawyer may have taken a look at that and said, well, this is not really what we need to do. We're going to amend the motion. But we never had an opportunity for that. And the Williams case says...
Under that theory, it would always be reversible error not to appoint a lawyer, because the lawyer could look at the motion and amend it. I know I don't want to write that opinion.
If the motion is sufficient to justify an evidentiary hearing on ineffective assistance of counsel, I don't think there's a case that you can imagine that a lawyer wouldn't be of assistance.
So
Why wouldn't you appoint a lawyer to represent somebody?
So you think a lawyer should be appointed on every post-conviction evidentiary hearing?
No, but I do think on every one that requires expertise, such as an ineffective assistance of counsel claim. Remember now, on ineffective assistance of counsel, you're talking about the defendant who was represented by this person, who was his advocate, now becomes his adversary. And it's a totally different kind of relationship.
That is the nature of every one of these cases. It's the nature of every 38500. You're saying that my lawyer was ineffective, and it puts you at in an adversarial relationship, and that's why the attorney-client privilege no longer is applicable. So that's the nature of every one of these cases, and so I'm struggling to to understand what was so complex about this case. The lawyer, the defense in this case could only be presented through the client's testimony.
Right.
So that was what his defense was, and I don't know that the lawyer had any other choice but to recommend that he testify, and that's what the client's complaining about now. He's saying, I was a 7-time convicted felon, and once the jury learned that, the case was over. But there was no other way. He had no defense other than, we knew this person. This was someone that I was familiar with. It's not just a burglary. That's what his defense was, and it could only have been presented through his testimony.
Well, the problem that I see we're going into is that there's a case that I've cited in the brief that's Williams versus State that says that what the court is not supposed to do in determining whether to appoint a lawyer to represent somebody is whether the claim has merit. The question is whether or not it's one of those claims that is deserving of having a lawyer appointed.
Well, whether there's complexity, and in this case, I'm struggling where the complexity was.
Well, why don't we look at the way the trial went, the hearing. The defendant, who was not given a lawyer, didn't know that he was supposed to proceed first. He didn't know how to make objections. In fact, he objected to his own question. He didn't know the difference between a question and an argument, which is not unusual for lay people. He didn't know how to object to an unauthenticated letter, and he didn't know that he needed an expert witness.
It's the complexity of the issue that's before the court. And here, I'm still trying to get you to zero in on and tell us what was complex about the underlying nature of the ineffective assistance claim.
First, if the claim is a claim that is worthy of having an evidentiary hearing, which the judge found that it was. First, it's an unusual claim. Usually the claim is that my lawyer didn't call a witness. This claim is my lawyer did call a witness. So first place, it's an unusual one. Second place, I can't imagine having an ineffective assistance of counsel claim litigated without having significant legal research.
Well, if the claim was that my lawyer was ineffective because she did call me, that doesn't require any evidentiary hearing. She either called him or she didn't. That's obvious from the record. The claim here was the lawyer's service was ineffective because she advised the defendant to take the stand. That's what the judge needed to figure out, is what advice did the lawyer give the client. And when your client says, I was under the influence of all these medications, I don't remember what she told me. Can't the judge then resolve that on a credibility issue in favor of the state? Seems to be what happened here.
Well, I suppose so, but if you imagine that you're presiding over this hearing and you've got NUZZI out there and he's floundering around, he doesn't know what he's supposed to do, he doesn't know how to ask questions, he doesn't know what burden he has, he doesn't know what witnesses to call. Even at that point, the judge could have said, Mr. NUZZI, I'm sorry, I made a mistake. I'm going to go ahead and reset your case for 60 days and I'm going to appoint a lawyer to represent you. What was wrong with that? I mean, there's nothing wrong with that. That's what should have been done in this case.
Well, could have been done and should have been done doesn't mean abuse of discretion.
Well, I think what should have been done does show an abuse of discretion.
Stone v. State case, the trial court declined to appoint counsel. The issue was the same. The defendant was saying the lawyer is ineffective because of her advice on whether the defendant should testify or not. And the court there, 3rd District, said, that's fine. You don't have to appoint counsel in that type of case. That case seems directly on point here, not mentioned in your brief, but it seems like that's directly on point. The Heidelberg case from our court says basically the same thing. No counsel is needed if that's the only issue, is dealing with the advice that the lawyer gave to the client. It seems this precise issue has been resolved by at least 2 of the districts. How did Judge Perkins abuse his discretion by following the case law?
I don't know that the NUZZI case is exactly like the other cases. We're talking about an unusual claim here. We're talking about a prisoner who has no legal training whatsoever. We're talking about a person who wants to be brought before a court and be given justice, at least be given a fair opportunity to be heard, and he doesn't get it. Now, that's the problem here. I'd like to reserve the rest of my time.
All right, thank you.
May it please the court. My name is Nora Hall, and I represent the state of Florida in this matter. The trial court did not abuse its discretion when it denied appellant's motion to appoint conflict counsel for his evidentiary hearing. He wasn't entitled to counsel for the evidentiary hearing. The courts have consistently held that Sixth Amendment protections do not apply to post-conviction proceedings, and the trial court properly analyzed it according to the factors in Graham, that the issue was not complex and it did not require legal research. So the trial court properly ruled in this matter.
Thank you.
So if the court has no questions, I ask, the state will rely on its brief and ask you to affirm the rulings of the lower court. Thank you.
I think it's a little disingenuous to say that the issue that was involved in an ineffective assistance of counsel claim is a simple issue and it doesn't require any research. I mean, it just flat does. I can't imagine having a successful claim like that without it being fully fleshed out and researched and prepared and presented in accordance with the rules of evidence.
Your client testified that he didn't know that he had a right not to testify, right?
Yes.
And if he had just listened to the opening instructions that the trial court gave, he would have known that.
Well, I don't know how many prisoners you've dealt with, but some of them are not all that smart. I don't know about Mr. NUZZI, but you have to take it as it is, I think.
If we were to agree with you, Mr. Eaton, on this case and find that counsel should have been appointed, the relief that you've requested here is that we send this down for a new trial. That kind of skips a step, doesn't it? Shouldn't it go back for another evidentiary hearing with counsel? We can't
Yes.
really send this down for a new trial.
Yes,
like
that's
you
what
have.
I meant. I should go back for a new hearing on his post-conviction relief motion.
Okay. Well, you've requested a new trial, and I don't think that's something that we can do at this stage.
No, I meant a new trial on the post-conviction relief motion.
All right, no problem.
Thank you.
Thank you.